Hi, my name is Haley Young, and I will be explaining the 7 parts of a trial. A trial might sound like a simple concept, but really there are many factors involved, making it a process. First, I'll explain discovery and deposition. Afterward, I will walk you through preparation for a trial, the trial itself, the attorney's role, the courts, and then finally the roles of the judge, the jury, and the expert. To begin the trial process, after a crime or lawsuit has been filed, both the defense attorney and the prosecuting attorney will be able to request or obtain an order for any evidence or documents from the other. Any material that is proven relevant or isn't otherwise off limits may be used. This is called discovery before trial. A deposition is most often used in civil cases, but is when all evidence from the discovery is laid out for both parties to analyze. The point of this is to create a fair trial for both parties with no surprises. The deposition should reveal any inconsistencies, assess a witness's ability, and document all statements and processes involved. This is done by the opposing counsel with a certified court reporter to review all products of discovery and material. Once an expert has been approved and has shown all of their materials to the opposing counsel, they can start to prepare all of their documents and demonstrations for court. All of the expert's data needs to be summarized and put into common terms for the jury to be able to understand, while also having all of the original data available. The expert's hiring attorney will describe to them the setting of the court and where everyone will be seated. The goal is to get the expert acquainted with the atmosphere and to instill confidence before trial. Once the trial begins, the hiring attorney will have the expert qualified by presenting proper experience and qualifications. There is a lot for the expert to remember other than their own work. The expert witness must stick to his or her testimony without anything extra. It is important to speak slowly and clearly and only answer the question asked. Nothing needs to be volunteered. All mistakes must be corrected and admitted immediately in order to keep all credibility. There are 5 main parts of a trial. First is voir dire, when the witness presents qualifications. Next, the witness will give direct testimony, followed by cross-examination and redirect. Finally, the witness will be dismissed by the judge. The attorney, whether it be the defense or the prosecutor, has the most active role in trial. An attorney's role is to advocate and argue for a certain position. They present facts and evidence to the jury. The prosecutor's goal is justice, and the defense attorney's goal is to defend constitutional rights. The most popular strategy is to use objective physical evidence to argue for or against a position. For anyone who cannot afford defense, a public defender will be assigned. There are many courts in the U.S. with multiple levels, but most often it is within the state courts. At the highest level, there is the Supreme Court, but this is usually after all other options have been assessed. Unlike a state court of appeals, the U.S. District Court of Appeals must hear all appeals. States reserve the right to reject, but the federal level all must be investigated. State courts have more control as far as interpreting state law versus federal law. The judge will be the absolute authority at trial and should be addressed as Your Honor. The judge is meant to be completely impartial and free of any outside influence. If it seems as though the judge was impartial or was unfair, then an appeal may be requested where a panel of 9 judges would investigate the case. The judge has the power to give punishment for any misconduct inside or outside of the courtroom during trial. The jury is a group of 6 to 12 peers that have been proven unbiased and will ultimately decide guilt or innocence. Occasionally, they will have a say in sentencing. The jurors also go through the process of voir dire by the counsel before they may officially become a juror in the case. If they cannot agree on one verdict within the proper amount of time, a mistrial may occur, and the case may or may not be tried a second time. Finally, we reach the expert, the role of the expert. The expert witness has to use their knowledge and skills to assess and assist in reaching a conclusion in the case. Even though an expert has their own work and evidence to back up their science, science is objective and may be cross-examined. An expert's data does not have to support their hiring attorney's argument. The expert is there to collect facts about the case and provide their own scientific conclusion regardless.